All right. Well, again, welcome. Happy Friday to everyone. My name is David Walton, Event and Program Manager for the Tompkins Chamber of Commerce. And I'd like to welcome you all to today's webinar in our COVID-19 Business Readiness series. I'd like to start by welcoming our attorneys today, Mr. Larry Bousquet, Joe Porcello, and Josh Werbeck from Bousquet Holstein. Today, these gentlemen will be hosting a discussion on contractual obligations and COVID-19 with a focus on force majeure and other excuses for non-performance. I'd like to thank you all for joining us today, and thank you to our L.E.A.R.N series sponsors, Tompkins Trust Company. If at any point you have questions for our attorneys, please feel free to use the chat box located in the bottom right of your screen. Feel free to post any questions that you may have, and then at the end during our Q&A time, we will be able to address any questions that come up during today's webinar. Additionally, just giving everyone a heads up that today's webinar will be recorded and will be posted on the Chamber of Commerce's website, and we will share that link with Bousquet Holstein so that they can get it out to any of their clients or people that they would like to share in their space as well. So without further ado, I am going to go ahead and turn things over to Joe so he can maybe do some further introductions and get us started today.
Sure, I'll let Larry give the introductions. Share at the presentation.
Thanks a lot, Joe. Welcome everybody. We have a good group here today, and hopefully we'll have an opportunity to talk to each of you a little bit later in the presentation. So I'm an attorney with Bousquet Holstein, a law firm with offices in Ithaca, Syracuse, and New York City, and really want to thank the Tompkins County Chamber of Commerce and David for arranging this and putting it together and bringing you all here into Zoom world. I'm going to introduce my partners, Joe Porcello and Josh Werbeck, and you'll be hearing from them a little bit later. As David mentioned, our subject today is force majeure and other excuses for non-performance of contractual obligations as a result of the pervasive COVID-19 pandemic. We have seen over the last month or so a number of our clients on each side of this issue declaring force majeure or having force majeure declared against them, and a number of clients we've actually seen in different contexts with different contracts on both sides of the issue. So we're going to address what your contractual rights are when, as a result of the pandemic or as a result of the required governmental closures, a party to a contract to which you are a party declares force majeure to excuse its performance, or you believe that it's necessary to notify the other party to a contract that you should be excused from performance. First, I'll give you a little bit of overview of what we're hoping to do for the next hour. I'm going to give a brief summary of the concept of force majeure and of the other concepts that are associated with commercial contracts that may excuse or suspend performance. Joe is then going to provide a list of steps that will assist you in evaluating and determining the strength of your arguments and whether you will legally, on the one hand, have the right to either demand performance, seek damages, or grant an excuse, or on the other hand, seek to excuse yourself from performance of your contractual obligations. Joe is also going to share some practical considerations for seeking negotiated solutions in these unusual and fraught times. Josh is then going to talk about specific concepts relating to real estate contracts and leases. So first, a few of the rules of the road. In New York State, force majeure provisions in contracts are read very narrowly. A force majeure clause generally limits damages or excuses performance when certain specified unforeseen circumstances beyond the party's control prevents either party from fulfilling its obligations. The concept is a civil law concept. It's a creature of contract and not a common law concept. The success of a contract party declaring a force majeure will depend greatly on the specific language of the contract. And in New York State, the contract language is strictly and not expansively construed. Force majeure is most likely to be successful if the event is unforeseen and outside of the control of the party declaring the force majeure, and the event enabling the excuse from performance is specifically identified in the contract. So contracts that specifically include pandemics or governmental actions in the litany of potential force majeure events will be more susceptible to a force majeure declaration than a contract that has very general language. It's important to note that if a party declaring a force majeure is relying on its own acts or omissions or on economic restraints rather than on legal or physical restraints on performance, the declaration is unlikely to be successful. So what if your contract doesn't have a force majeure clause? Are there other excuses for performance that are available to a contract party who cannot perform because of the effects of the pandemic or because of governmental action? And the answer is a qualified yes. There are three concepts that exist at common law. Remember, I said that force majeure is basically a civil law or contractual concept. There are three concepts that exist at common law that may apply. The concepts of impossibility, or its near cousin impracticability, and the concept of frustration. And frustration is probably the easiest one to understand. Frustration of purpose applies when the object of the contract simply no longer exists. With frustration, the contract can be performed, but the object of performance is no longer a possibility. So for example, if a sporting event has been canceled by a third party, a contract to create a billboard for that event is still possible, and payment is still possible. So the contract could be performed, but the object of the contract no longer exists, and a strong case for frustration can be made. On the other hand, impracticability of performance or impossibility of performance may discharge a party's obligation to perform under a contract where events occurring after a contract is made that are no fault of the party seeking to be excused, and that's an important point, make it impracticable or impossible to perform that contract. And those of you who are involved in the sale of goods under the Uniform Commercial Code, there is a provision which is a little bit more narrowly read that relates to the impracticability of performance. So in the context of the COVID-19 pandemic, you can imagine numerous circumstances that may make performance impracticable or impossible. For example, a lack of raw materials or supplies because of an unforeseen shutdown of your sole source of supply that prevents performance. A company may no longer be able to ship product to its customers because of governmental action or a forced closure or closures along the supply chain. Or a contractor can't enter the premises to perform because someone is infected with the COVID-19 virus. One very important thing to keep in mind is that impracticability is a legal concept that has not been successfully invoked to enable a buyer to be excused from his contractual obligations because performance would create a financial hardship on the buyer. New York courts do not excuse performance under a declaration of force majeure, impracticability, or impossibility based on financial difficulty or economic hardship. So, as with force majeure, the applications of the common law concepts is very fact specific. Depends very much on the language of your contract and the circumstances surrounding the breach. It's important to note that these concepts also do not necessarily justify the termination of a contract. Impracticability of performance or frustration of purpose or force majeure that is temporary may suspend a party's duty to perform only while the impracticability or frustration exists, but that party may still have an obligation to perform after the impracticability, the force majeure, or the frustration ends, depending on the circumstances. So that's sort of your general outline of these concepts that have come up repeatedly over the last several months. At this point, I'd like to hand the presentation over to Joe, who's going to give a practical guide on the steps for dealing with the issues of contractual performance in this unprecedented time. So, Joe, I guess we can call it the floor. The Zoom camera is yours.
Thanks, Larry. So I'm going to discuss various considerations about how you would work through analyzing an issue relating to force majeure. And my background is helping clients resolve commercial disputes. And part of that is litigation, but a large part of it is helping clients avoid disputes and negotiate favorable, mutually amicable outcomes. And so you'll see here some comments about framing a dispute for potential litigation, but the objective is to avoid the dispute in a way that allows you to move forward with your business. And so the first step in analyzing a force majeure issue is whether it's your own performance or a counterparty's performance, looking very closely at what exactly is impacting the party's inability to perform. For example, is it the COVID-19 pandemic itself? That is probably less likely in terms of the impact on ability to perform. More likely it's a government response measure, the New York State pause and the various regulations associated with it. Municipalities and states around the country have shelter-in-place orders, stay-at-home orders, and other restrictions on non-essential businesses. Those sorts of restrictions are something that are key to focus on. There may be supply chain issues. Reduced consumer demand could be a consideration for some businesses considering non-performance, or economic hardship. But as Larry had noted, and we'll talk about a little bit more, under New York state law, economic hardship, financial considerations generally are not a valid excuse for non-performance. The second step in analyzing this issue, and equally as important to the first, is identifying whether or not there actually is a force majeure clause in the contract. Now, many contracts do have a clause, some do not. If there isn't a force majeure clause, one or more of the doctrines that Larry spoke about a few minutes ago may apply depending on the circumstances: frustration, impossibility, impracticability. If there is a force majeure clause in the contract, the next step is to look very, very closely at the precise language used, because clauses are different. Some are narrow, some are broad, some are very broad, but you won't know until you look at the clause. And typically a force majeure clause will list specific events that are considered force majeure events. And so you've identified what is impacting the performance, and now you got to look at the contract and see if that event is specifically listed, or perhaps it's specifically excluded. And if it's specifically excluded, there won't be an ability to declare force majeure. Now, there also might be catch-all language that might say, any event beyond the party's reasonable control, for example. Now, under New York state law, the clause is interpreted narrowly, and that applies to the catch-all language as well. And so if there is the catch-all language, that doesn't mean anything under the sun could be a force majeure event if it's beyond the reasonable control of the parties. It means events of like kind to the actually listed events are also included. So it's more narrow than that. And something that is critical to understand is just because you have a force majeure clause, and just because there is a force majeure event, like the COVID-19 pandemic, that is not sufficient alone to validly declare a force majeure event or a force majeure under a contract. And the other specific terms of the contract will determine whether or not you can validly declare force majeure. Now, one of those considerations is, what is the specific standard or criteria under the contract for invoking force majeure? And it's going to vary from contract to contract. You'll see language in many clauses that talk about the event having to be unanticipated or unforeseeable by the parties or beyond the parties' reasonable control. But then more specifically, there will be a requirement that has language like the event must, that performance is excused if the event prevents, delays, or hinders performance. And just looking at the language used there, you can tell that we're looking at a spectrum of standards here. So prevents being the most restrictive, and delay and hindering, allowing a little bit more wiggle room to make arguments that your performance falls within the ambit of the force majeure clause. Some other language you might see is renders performance impracticable or impossible. Again, this is setting up the standard against which you're applying your non-performance to determine whether you can invoke the clause or a counterparty can invoke the clause. Now, we've been focusing on the force majeure clause itself, but it's important not to lose the forest for this one tree. You need to take a holistic view of the contract, because there may be other provisions that impact whether or not performance is excused, or that allocate a particular risk to one of the parties. And just as a note here, courts in New York and elsewhere do not rewrite contracts based on a force majeure provision. So if there has been an allocation of a risk, the force majeure clause does not undo that allocation that the parties mutually agreed on. Okay, but if there isn't a risk hasn't been allocated, you can look elsewhere as to issues for excuse. Some of those provisions are payment provisions. There might be a customer right to withhold payments when the obligations of the counterparty aren't performed, even if there is a force majeure. The material adverse change provision, if it exists, might provide a right to terminate the contract in the event of a change like the circumstances here with COVID-19. The warranty clauses, damages provisions, technical specifications, and performance standards also could provide guidance as to whether performance can be excused or whether risks have been allocated to a particular party. A critical step in determining your rights with respect to and obligations under a contract when force majeure becomes an issue is conducting a diligent investigation of the facts and how the claimed event impacts your or your counterparty's business. Under the law in New York State, generally speaking, the specific force majeure event, say a government action, if that's what's been claimed, has to be the direct cause of the non-performance. So if there is a longer chain of causation at issue, you may not be able to invoke force majeure. And this is looking at, for example, if you have a situation where you're claiming that you can't perform because you shut down your plant and are unable to accept deliveries of raw materials, ingredients, etc., except the shutdown of the plant was it's your own initiative, not required by the government, but because costs had increased, or because conducting business had become too difficult under some sort of regulation. And so you get an attenuation from the actual event that didn't absolutely require the shutdown, and you start raising questions about whether there's an adequate causal link. Even if you do have a causal link, it's necessary to make sure that there isn't something else that you could do to mitigate the non-performance. In other words, could you go out and find new customers, new markets? Can you identify alternative transportation for a product or to obtain your inputs? Those sorts of things need to be considered as to whether non-performance is truly precluded, or performance is truly precluded by the force majeure event. And again, as Larry had said, and I noted earlier, under New York state law, just because performance is more expensive or burdensome or creates a risk of financial hardship for a business does not make it a valid excuse. And that is not what force majeure clauses generally address, unless, and this is a big caveat, the clause itself or some other provision in the contract allocates that risk. Now, I want to make a note here, and this is from a dispute resolution perspective. When you conduct the investigation regarding the event and its impact, you need to preserve and collect evidence that's relevant in case you need to make a case in court. Hopefully you won't have to, but it's important that you've laid the groundwork to enforce your rights. So the next step, and this is more of a ministerial step to a certain extent, relates to notice. So many clauses require that a party invoking force majeure provide timely notice. Now, a force majeure clause may not provide a time frame. It may provide a time frame. Sometimes notice deadlines can be as short as a few days. So this is something that needs to be, if there is a potential impact on your performance, to raise this issue quickly. Now, in drafting a notice, if you're the party that is invoking or attempting to invoke force majeure, you take care in drafting the notice to identify the event, the grounds for invoking force majeure, specifically state how your performance has been impacted. You want to make out the best case you can, because this notice, if you do get into a dispute, particularly a litigated dispute, this notice is going to play a prominent role. It's also going to provide a framework for the parties to try and work out some resolution. So you want to be specific and accurate. And then on the issue of disputes, this is always a concern whenever you have a dispute. But here, you need to be cognizant of documents you're generating internally about your ability or inability to perform under the contract. Because if you get into litigation, assuming they aren't privileged, attorney-client privileged, they will likely be discovered by the other side and can be used against you. So anybody who sends out an email saying what the real reasons are for invoking force majeure, for example, well, it's tough economically, or we have reduced consumer demand. Well, that's not going to fly under New York state law. And so those are the sorts of things you want to be careful not to say in non-privileged emails or other non-privileged communications. And the next step is, you have your force majeure clause. One of you or a counterparty may invoke it, but if you are the one invoking force majeure, how does that impact other contractual obligations? So we've had clients who, like Larry said, are on both sides of the force majeure issue. And this can be within the same supply chain or in different supply chains or as to different business relationships. But this is particularly thorny if you're on both sides within the same supply chain. So for example, you could have a supplier of raw materials who claims force majeure because they have had some impact from COVID-19 and they can't provide you any or all of the required inputs under the contract, and they may declare force majeure. That puts you in a difficult position. You then may not have the ability to produce your products, to which you have a corresponding duty to sell to your own customers. And so you may be in a position where you need to invoke force majeure. However, it is often the case that force majeure clauses in different contracts have different language. So they're asymmetric. And so that can create difficult issues in terms of the strategy for handling those various relationships in the single chain. And it's important not to take inconsistent positions based on similar contract language and to have a unified strategy. The next consideration, and this is one of the very most important ones, is we're going through a difficult time now in the short term. The tough times will pass. We don't know when, but they will. And it's easy to get into a short-term view. We would encourage businesses to consider the long-term view as well. We spent years building strong relationships with business partners, and you don't want to throw them out the window without very good cause. And so when you're considering force majeure issues, it can be helpful to consider the totality of relationship with each of your counterparties, and to evaluate whether you're able, and if you are able, whether you're willing to accommodate some key business partners in the short run, even if it may cost some money, and consider whether there is a commercial resolution to the force majeure issues where some of the risk that hadn't been allocated in the contract or anticipated by the parties can be spread, so that you don't end up with a situation where key business partners are going out of business, and after the pandemic's over, it has a negative repercussions. So what happens after force majeure is invoked? And Larry touched on this. It depends on the contract language. So the contract could be terminated. That's less likely. Contract language may say, though, however, that if the force majeure event continues for, say, 30 days, the contract could be terminated at a party's option or automatically. It also might be the case that performance is just adjusted or suspended throughout the duration of the force majeure event. Another critical issue for both parties is mitigation of damages. If you're the party who believes they can't perform, you need to take all reasonable steps to perform. So if that means finding new transport, like I had mentioned, finding new markets and customers, if you assert lack of storage capacity. For example, there's a glut of oil right now. Are there abilities to reallocate this where product is stored to clear out space? Those are all things that you should consider doing. And on the flip side, if you should be considering if you are the party who is not receiving the performance that was contracted for, how can you mitigate those damages? And then it is important, like we had mentioned, to cooperate with your counterparty to try and work out a resolution if it's possible. But you should only do that when reserving your rights. So if you're writing letters, you always include a reservation of rights at the end. Make sure that you are able to assert your rights later if it becomes necessary in court. And that's the end of my presentation. I'm going to turn it over to Josh to talk about special considerations for landlords and tenants.
Thank you, Joe. I'm Josh Werbeck. I'm an attorney in our real estate group. I work out of our Ithaca office and our Syracuse office. I've done a lot of Zoom calls lately, especially from this room, but this is the first time I'm realizing that my office light forms a halo over my head. I'm not in heaven. I'm in Syracuse. It's close, but I'm not there. So I'm going to talk about some particular issues for landlords and tenants and lenders under our current situation. The pandemic has had a particularly significant impact on our landlords and tenants. New York on pause has caused many tenants to close. Certainly the restaurants and bars are for the most part closed. They're trying to stay in business with delivery and takeout, but it's different. Retail stores many have closed, some offices are closed, and all of these closures are affecting those tenants' ability to pay the rent. The same can be said with our residential tenants. Some are out of work, some are on unemployment or waiting for unemployment, and some are dealing with illnesses, all of which probably prevent them from making some rent payments. So without question, the pandemic is affecting the enforceability of our leases. And the principal leverage for landlords, at least, the eviction, has been on hold. Courts are closed except for essential matters. And we have seen a lot of reopening lately, a lot of virtual court opening, but evictions are last on the list for the courts. And right now, we're operating under an executive order that put in place a moratorium on evictions outright. This is from Executive Order 202.8, March 20th, 2020. There shall be no enforcement of either an eviction of a tenant, residential or commercial, or a foreclosure of any residential or commercial property for a period of 90 days. This is a broad order from Governor Cuomo. It applies to, like it says, both commercial and residential tenants cannot be evicted right now. And, we're a few weeks into it, well, more than a month into it now, but it still goes on for more than another month until June 18th, 2020. So until that time, evictions are under pause as well. The eviction moratorium does not apply to only new evictions. It is also affecting evictions that were underway pre-March 20th. For example, if you obtained an eviction warrant after what could have been months or weeks of litigation with a tenant, and that warrant was in effect or stayed until just right before maybe April 1st or March 19th, the marshals and sheriffs in New York State have been directed not to enforce those evictions or physical move-out orders until the eviction moratorium is over. I had a client in that particular situation. We had a difficult residential eviction that took us several months to finish through several court appearances. The eviction warrant was eventually issued, and we all agree, the court ordered that it be stayed until April 1st. We had scheduled time with the marshal to do a physical move out on that date, something that's very unusual in and of itself. And then 10 days before we were set to enforce that warrant, the moratorium went into place, and now we're adding at least 3 more months to this already long process. This stay of enforcement is the position of most of all the courts I've heard from, and also the New York State Attorney General. She's issued guidance directing the marshals not to enforce warrants. She's also reminded landlords that not to rent gouge during this period, and that not to engage in any constructive evictions that could be deemed unlawful, and that would include trying to force tenants out through unlawful increases to the rent or withholding services like electricity or water or something like that could be deemed a constructive eviction. So we know we're not allowed to enforce our agreements through eviction right now, but what can be done during this time? There had been some debate initially, but now I think it's pretty clear, at least under the New York State moratorium, that predicate notices, any of our pre-eviction notices, can still be served. So if you have a tenant that's refused to pay rent, and rent's due today, so if you don't get the rent, you can still serve the rent demands and rent reminders that are required under New York State's Real Property Actions and Proceedings law. If you have a tenant that's violating a lease, you can still serve a notice of default, and you can still serve termination notices. You just be aware that you won't be able to enforce these notices and demands until after the moratorium is lifted. I note that process servers have been deemed an essential business under ESD's guidelines. So if you need to use a process server for maybe that rent demand process service, it is possible to hire someone to do so. I note that eviction moratorium is not rent forgiveness. So the rent is still due, even though landlords are in a tough spot enforcing that rent. It's not rent cancellation, and there's actually a rent strike today, a large national strike that's typically, we're typically seeing in the larger cities, New York City, LA. I'm not aware of any protests in central New York at the moment, but this is a May Day protest day. And capitalizing on some of that political action, there are bills in both New York State and Congress, federal Congress, to have rent canceled. So there's a New York State bill that's been around for several weeks now, which would suspend rent and mortgage obligations for 90 days. I took a look, and there's no Ithaca area legislators supporting the measure. Syracuse's Senator Rachel May is a co-sponsor. And then there's a federal rent cancellation bill that has very little support. It was proposed by Congresswoman Omar out of Minnesota. It's HR 6515. I think it has like about 10 or 15 supporters, so very little chance of the federal law passing. Initially, Governor Cuomo had said he didn't support this legislation, and we had heard that in the CLEs that we're taking as part of the real property bar section. But lately, in the last week, he hasn't come out saying he supports a rent cancellation bill, but the governor has indicated that he does support exploring at least some options, such as rent vouchers or other ways to help people pay the rent. So we have the New York State laws that are affecting the enforceability of our leases. Then we have federal laws that are affecting how we can enforce our leases. The CARES Act that was enacted in March 27th, just over a month ago, has two important sections for the enforceability of leases. It applies to covered dwellings, which is an important definition, which I want to dig into a little bit in the next slide. But there's two sections, 4024B and C. B is the federal eviction moratorium, and it's for a period of 120 days from enactment. So it expires initially in July 25th. Now, in some ways, it's broader than the New York State rule. In some ways, it's less broad. It's less broad because the New York State rule moratorium applies to both commercial and residential leases, whereas the federal law only applies to residential leases. But the federal law, the New York State law is 90 days, and the federal law is 120 days. So it's a much longer moratorium. Now, Section B clearly also applies to, it's an eviction moratorium, but it's also a moratorium on charging fees for late payments or any other charges. And that's for non-payment of rent. So like a late fee is not going to be allowed during this 120-day period. Section C adds another 30 days advance notice of any notice to vacate. So if you have a tenant, you have to wait the 120 days, finish your eviction, and then they're going to be entitled to a 30 days advance notice before the eviction can be carried out. And it's arguable under this section that this section doesn't only apply to non-payment, but it would apply to evictions for violations of lease rules or even holdover evictions. So there's still some debate out there, and there's some conflicting guidance from, for example, the Congressional Research Services that's indicating it is broader, and HUD, which indicates that this is a law strictly restricted to just non-payment issues. So we're looking at maybe 120 days from enactment plus another 30 gets us into late August as the earliest date to enforce evictions if you're a covered dwelling. And so what does that mean? What is a covered dwelling? A covered dwelling is a residential abode that is in a property that participates in a federal assistance program or is subject to a federally backed mortgage loan. Federal assistance programs are like Section 8, other rent voucher programs, very easy to know if you fall under that area. The much larger group of covered dwellings, though, are those that are backed by federal support. And so this is going to include FHA mortgages, USDA mortgages, VA mortgages, and any mortgage that has been packaged or securitized or sold in the secondary market in association with Fannie Mae, Freddie Mac, which is a huge group, maybe even most of the mortgages in our community and across the nation. So if you obtain a mortgage from a large lender, for example, it's likely that within days of closing, even though the local branch originated the loan, closed the loan for you, that it was sold on to the secondary market in securitized and federally backed instruments. How do you know? You could call and ask your initial bank or your servicer if it's a federally backed loan, but there's also a website that's been set up from Freddie Mac. I have the link up there, just Google. You could just Google the question and it comes up to a way to find out for landlords and for tenants if they are a covered dwelling under the law. So we talked about the eviction moratoriums, the fee moratoriums. Those are relief directed at tenants, but has the government done anything to help landlords or mortgagees or borrowers? And it has. There's the CARES Act has the eviction moratorium section, but it also has a mortgage for foreclosure forbearance provisions. And at the federal level, if you are a covered dwelling, if it's a 1 to 4 unit properties, these are considered single family units under the federal rules, then you're entitled up to 2 180-day forbearance periods, so up to 360 days of deferment of your payments if you can attest that you've had that COVID has negatively affected your ability to pay. And it also then the CARES Act has a second section that applies to multifamily dwellings, 5 or more units, so apartment complexes that might have a federally backed mortgage. And these sorts of mortgages are entitled to 3 30-day deferment periods. Those are 2 federal, again, those would only apply to the federally backed covered dwellings. Under New York State, DTF has recently, I think it was just a week or 2 ago, issued guidance directing any New York State regulated mortgages for residential mortgages to agree to 90-day forbearance periods for borrowers that request them. But the guidance is specific that it doesn't apply to commercial mortgages. So there's a question if you have a single family residence under just a typical residential loan that you're renting out, could you apply for forbearance under the New York rule? It's something we'd have to look closer into. So what does all this mean for landlords with lease enforceability issues? Like Joe said, we're helping all of our clients review all of their lease terms and contracts closely. Is there a force majeure issue? Is the provision in there? Walk through the steps that Joe outlined. Also, if we're prevented from evicting at this point, what pre-eviction steps can be taken right now? Can we start serving our notices to cure, our rent demands? Those steps often take weeks to complete, so it's still good practice, even though we might be prevented well into the summer from litigating the issues, to start these notices now. And then, of course, there might be the mortgage forbearance options too for landlords that are struggling. In all cases, we're stressing to our clients that communication between landlords, tenants, lenders is key. There's probably opportunities to craft solutions to all of the problems that are coming up. And we've had good luck so far working on deals between landlords and tenants and between borrowers and lenders. And just as a couple of examples, quickly, we've worked out deals with tenants where we've delayed rent for 2 or 3 months, and then the rent that would have come due during those periods is spread out over the next year, so that it's, even though the rent goes up for the second part of the lease, it's not a huge increase for the tenant. We've had great arrangements where we've delayed rent and it's just a lump sum repayment at a certain date. And we've made some agreements that where the rent was reduced, but the reduction was subject to the tenant's receipt of government assistance. So the rent is reduced, but if you get this particular grant or loan, then the rent is not reduced because you would then have the money to pay. And with regard to our help with lenders and borrowers, it's been my experience so far that, especially with the local banks in our communities in Ithaca and in Syracuse and in Auburn, we've seen lenders have been more than willing to work with borrowers, even where they're not required to under the CARES Act, on forbearance agreements, on short delays, 2-3 months. And it just starts with a phone call to the servicer or the bank representative that you've worked with. So there are options. Thank you.
Okay, at this point, we'd be happy to take any questions that anyone in the audience has.
And I know that everyone.
David, can I jump in with a question? It's Jerry Dietz.
Yep, Jerry, you're doing exactly what I was about to say. If anyone has any questions, just unmute yourself and you can ask the team direct. Happy to have you here, Jerry.
Yeah, hi, David. Hi, Josh and Larry and Joe. Thanks for doing this. Great stuff, really helpful. I've experienced much of what particularly you just talked about, Josh, over the last month or so. I will say my experience has been, at least with April, that we had a very good month with collecting April rents, and that while we did have to negotiate with a few tenants that were not able to make rent, mostly actually restaurant tenants, but some residential tenants as well. It's been a very amicable, and it's gone very well. And I'll echo what you said about the banks. My question though has to do with future leases. We are in a situation where we have signed, as many landlords in Ithaca, and probably up in Syracuse too, have signed leases that will begin, or scheduled to begin, in June, July, August, for the upcoming school year. What are your thoughts about those leases and the enforceability of those leases given COVID, and do they fall under? Are your thoughts they would fall under the same sort of negotiation practices that the current leases fall under?
Yeah, those leases are still enforceable, and depending on what the terms say, we'd have to complete, if there was an issue, we would complete the analysis that Joe kind of laid out on in L.E.A.R.N on enforceability. But from a strict real estate perspective, those leases are enforceable. Although if someone was to breach their very first payment, a lot of students moving in, July 1st leases, August 1st leases, we're going to be restricted under the litigation, the court closures overall, and then also the eviction moratoriums too will enforce us to getting into a summary proceeding or something.
I think it's a different issue if if Cornell or Syracuse University doesn't open.
Larry, which is something that is a distinct possibility, or at least if they open it, maybe with a very, very limited on-campus learning presence.
Yeah, so I think you still have to go through the review of whether impossibility or frustration applies in a situation like that.
Right.
Have you had that experience, Josh, with residential leases?
Not yet, but it's just, Jerry, just like you're suspecting, it's already coming up with students. The colleges, obviously they have the means to be more flexible, so they're already granting refunds and forgiveness on their leases or licenses for their dorms. But private businesses don't have the same luxury or endowments to support that sort of tactic. So it's an area that we're watching. I think those leases are still enforceable, subject to the provisions that Joe and Larry talked about, a frustration or impossibility. But
yeah, it's become. That all of that coupled with the the new legislation around landlord tenant, just giving notice has made the landscape a very, very difficult one to operate in.
Yeah, 2019's changes were huge and just extremely frustrating for landlords across the state.
Yeah. Well, thank you. I appreciate you addressing that.
Okay, any other questions or comments?
Larry, it's Randy. I just wanted to say thanks to you, Joe, and Josh. I thought it was an excellent presentation, very, very focused on issues that are front and center these days.
Well, thank you for coming, Randy. It's so nice to hear from you.
Yep.
I hope you're all well.
Yep, everybody's doing fine here. Hopefully the same with all you folks.
Working remotely is getting old.
That's true.
agreed.
All right.
Okay, well, if there aren't any additional questions,
David, thank you very much for
no, you go right ahead, Larry. There's a little bit of a delay on your camera, but I got you now. Go ahead.
oh no, I was just thanking you, that's all.
Oh, all right. Well, no, I was about to thank you too. So we're like-minded. I do want to thank Larry, Joe, and Joseph for being here. I'm sorry, Larry, Joe, and Joshua for being here. You guys were great, and I want to reiterate Randy's praise of the presentation. It was very concise, and you guys were very focused. I see that all of your contact information is there. Typically, people will ask the question of, hey, you know, can I get a copy of these slides? And I had talked to Joe prior, and he was like, if anyone's interested in getting any of the slides, or if you have additional questions that come up later, you can be more than happy to email him and he can get your questions answered, and he'd be more than happy to share today's slides with you. This video, like I said, will be made available on the Chamber's YouTube page. And just giving you guys a quick heads up that Bousquet Holstein will be back next Friday. We will have another webinar that takes place with them where we will provide attorneys that will be available to kind of be experts and ask any questions, answer any questions that you may have to ask regarding employment, taxes, SBA loans, commercial contracts, landlord, tenant law and rights, and insurance coverage. So, Joe, did you want to speak about that a little bit more, or did I do a good enough job of covering next Friday's webinar?
I thought you did a terrific job giving a summary. The idea is that there's a little bit of information overload. I think we may have contributed a little bit to that today, and it's you know, a forum to ask questions that folks might not have had the opportunity to ask previously. And you know, drill down onto kind of some of the ambiguities that they see in some of the circumstances that they're confronted with now.
Awesome. And in kind of giving everyone who's going to watch this later and people that are here today for the webinar, when Joe and I were talking about setting up some potential webinars for the Chamber with Bousquet Holstein, one of the things that I had shared was that we have so much content that's available right now from all of the previous webinars that if people wanted to go back and kind of rewatch or watch for the first time the webinars on any of those topics and wanted to ask additional questions, creating a space for people to do so would be very helpful. So to answer your question, Jerry, the time next Friday will be this same time from 12 to 1. The reason we've been trying to schedule the webinars during this time is that as we are all working from home, this would be a good excuse for you to kind of force yourself to take like a lunch break and also get some information during that time as well. So 12 to 1 next Friday. Next Friday's date is May the 8th. Yes, we are in May, as crazy as that sounds. May 8th from 12 to 1, Ask the Experts webinar with attorneys from Bousquet Holstein. So on that note, if there aren't any additional questions, again, another thank you to our panel today. Another huge thank you for everyone who was able to attend. And this video will be made available later for you to share and download on the Chamber's YouTube channel. All right.
Thank you.
All.
Bye-bye.
Hey,
Have a great weekend. Talk to you soon.
be safe.
Bye-bye now.